let's talk about business organizations. So one of the roles of a startup lawyer, like the type of lawyer that Alpha Lab needs, is a lawyer that can understand the business needs of its clients. And so, getting in the mindset of being a business lawyer is really different from being a litigation attorney, even a business litigator. I mean, lawyers get a bad rap because they seem to always be looking for problems. Things that people did wrong, catching someone and finding a way to sue and things like that. And business lawyers really have a different mindset. The business deals only happen, they only work when there's a meeting of the minds, where there's some consensus, where there's some agreement, because people only get involved in a deal when they both feel that they're going to benefit from it. So you need to have that mindset. How do I achieve someone's perspective? How do I help them meet their goals? And that involves a lot of listening. You have to really understand what those goals are, but then it involves processing that through your legal knowledge, your legal filter. And the first step is helping make that critical organizational choice. And we went through some of the basics of business associations. And so what did we learn last week? Well, we talked about the basic choices. Those basic choices being partnerships, both general partnerships and limited partnerships. Corporations, both in forms of S corporations and C corporations, and limited liability companies, which have a member managed and a manager managed capacity. We briefly spoke about sole proprietorships. It's when a person just runs a business and has all the liability. We broke down partnerships into limited partnerships and general partnerships, and we talked about their essential aspects, their formation, their liability, how they're managed and controlled, their financial rights, their continuity of existence, what happens if someone withdraws, can they effectively cause the business to stop operating or extort them for money? Are those interests transferable? Is that the design of it, or is it meant to be kept within a group of people? And what happens with mergers? We talked a little bit about planning considerations. We're going to talk more today about the tax consequences from these choices. I'm not a tax lawyer, but I have learned a thing or two about tax, and so I'm going to try to step you through some of the tax analysis. And we're going to then wrap up today's class by applying all that we learned last week and all that we're going to review and cover this week to hypothetical situations for a particular client. My Green Home, a group formed by two individuals that are looking to go into business as co-adventurers for profit. And this is a very helpful exercise for you to think through, because you're going to be assessed on the exam with a series of questions that are very similar. It's going to be a slightly different fact pattern, but it's going to be a very similar situation where you're going to have to reason through why certain organizational choices would be better or worse for a given set of entrepreneurs, and you'll need to filter their business needs through your legal lens. There's no necessarily right or wrong answer, but there are some better answers. There are some choices in all this that can be ruled out right at the beginning, and we'll talk about ruling out the choices that are obviously wrong, and then sort of triaging what's left and sort of explaining why some choices would be better than others. And also, always there's going to be additional facts and follow-up. So the third thing would be to think about, what else do I need to know to make this choice? Do I have enough information to make a choice, or do I want to interview the founders a little more? What else would I need to know? So again, the three things you have to do: kind of rule out the choices which are clearly wrong, triage the choices which seem plausible, and then third, ask questions that would help you determine which of those choices is best. There might be a slam dunk answer, but usually there's a couple different entities that you could select from based on some other facts, and so pointing out which of those facts are going to be necessary is going to be very helpful in getting to the answer, because in a real client situation you would have the opportunity to dialogue with that client, to ask follow-up questions, and so we're going to sort of simulate that in this hypothetical and on the exam to help you get some of that basic intuition and that vibe of being a business lawyer helping with business planning. All right. So let's meet the client. It all begins with meeting the client. And our client for this hypothetical is found in your book. You should have read it. Oh, and by the way, I really appreciate all the work that you have all done. I hope you know I appreciate that, because for the rest of this entire semester, there's 70 pages of reading. So I recognize that the midterm required a substantial amount of effort, and I hope you realize I recognize that by the fact you have literally 70 pages of reading for the rest of this course. But it is a bit dense. I recognize that as well, and we're gonna take a couple weeks to work through it all. So please do keep up with the reading, because despite there being only 70 pages, that actually sort of in a way elevates their importance. So this would not be a good time to skip your reading. It is a very limited amount of reading, but it is all pretty important. And here what's important is how that hypothetical plays out for these individuals, because we're going to meet the entrepreneur, we're going to assess their business needs, we're going to make recommendations for organizational choices, we're going to talk about forming that entity, and then authorizing it to conduct business. And those are going to be our kind of 3 modules, 3 chapters, 3 components to get us to the finish line. So we want to start with the people involved, and we're going to try to understand who they are and what they want. And so in this particular hypothetical, you're approached by an individual named Brandon and an individual named Anita. And Brandon is a mechanical engineer. Imagine that he went to Carnegie Mellon. He has time. He's looking for a job. He wants to work. He's just graduated Carnegie Mellon, and so he's looking to put his newfound degree to work, and he has aspirations to be in a startup. You know, very popular these days being a startup. You can make a lot of money, and he's young and willing to take some risk, doesn't have any money, but has time. And he has some management skills. He had previously worked in business, and he has some management experience. So he would play the role most likely of a manager, based on his background, but we're going to try to see a little bit more about what he has to say about that. Anita, on the other hand, she's actually a full-time journalist. She's employed. And unlike some of you who work full-time and go to school full-time and take care of families full-time and other things, and you know, Anita is basically all full up with being a journalist. It's occupying 60 hours a week, but she's been successful. She's written a couple books, she's gotten a couple good publication deals, and so she has money, which is something Brandon doesn't have. And this might be a good relationship. You know, she has some capacity to understand publicity and marketing, and she's going to help out, but as she also has some background in finance. So she has money, understands finance. On the other hand, Brandon, who has engineering skills and management. And so they want to form a company called My Green Home, which is going to design and install solar panels on home roofs. Maybe not so popular in Pittsburgh. I think you ever go to the Home Depot and they have the stand there and they plug your address into the computer? It's depressing. I think I scored like a 24 out of 100 on the solar panel score. So, maybe not the industry for here, but you can imagine sunnier climes, the value here. So, given what we've heard about these two people, they walk in your door, and are you prepared to make a decision? What type of entity should they form?
I mean, so far it sounds like a partnership, one of them being general, one of them being limited, because she's pretty busy and has money, and he's just looking to work, so.
Okay, GP-LP structure, we're gonna put that on the table as an LP. Any other suggestions? Yeah.
LLC.
Sure, an LLC, we're gonna find that LLC is almost always an option, so long as we need the flexibility. Has more cost, it's a little more complex. But sometimes that extra cost is justified, right? An LLC could provide the same structure as an LP. Depends on how we structure it. It can be like a partnership, it can be like a corporation. What else could we install here?
S-corp?
Could be an S-corp, right? Could be an S-corp, and very easy to have separate management and control. So, maybe Brandon is going to be the manager. He doesn't have to be a stockholder. Anita could form the corporation, be the sole stockholder. Brandon could be the manager, and she could get flow-through benefits. And maybe she doesn't want float. We don't really know her tax situation, so maybe a C corporation. Maybe she wants to block from that tax liability. Maybe she wants to get other investors later. Maybe a general partnership. Maybe she wants to have. Maybe this involvement with finances could constitute some level of control, and she actually does care about that. The truth is, at this point, we don't have enough information to make a decision. We don't have enough information at this point. We need to know a little more. We need to know fundamentally, what do the individuals intend to give to the business? What is their intentions? What's their objectives? And what do they more fundamentally want to receive? I mean, we know what skills they have, but we don't know at this point what skills they want to provide. And we don't know what they want back at all. We don't know whether they want money. We don't know whether they want interest. We don't know whether they want share of the profits. We don't know if they want salary. So we need to ask some questions about the parties' expectations. The parties' expected contributions, would probably be based on their resources, but and we know then that let's go a little far. Let's suggest then that Brandon expects to dedicate primarily time. So if he wants to dedicate time, we also might ask, does he even need to be a co-investor? Maybe he's just an employee. So we shouldn't forget that a typical relationship, one person has a business, the other employs the other. We don't know from these set of facts that Brandon needs to be involved in the management at all. This could be a sole proprietorship where Anita simply employs Brandon and pays him a salary for his time. So we need to understand his risk portfolio. Does he want to have a chance at making 1,000 times an investment? Does he want a chance of getting stock options that are very valuable? Or does he need to feed his family and he needs a paycheck every week? So we don't know that at this point, and it's important not to jump to conclusions. At this point, knowing what we know, basically every organizational form is still on the table. So helpful hint, I'm not going to give you something this open-ended, right? Because it would just be a question of recitation. So we're going to talk about these organizational choices again, go through all that, and then at the end of today's class, we're going to then play through those hypotheticals with a little more granularity so you know how to advise them. All right, let's see how we'll remember last week. What's a general partnership?
This is 50-50 share of the, I know that the liabilities is like equally shared between the two, like you're just as much liable for the other party.
Yeah, so so general partnerships have have unlimited liability. That's one characteristic. How are general partnerships formed? Yeah, they can happen automatically. They can happen accidentally, right? It's simply defined as an association of two or more persons to carry on a business for profit. And so it's something that can be formed very easily. It costs nothing to form one. They can be formed by act of law simply by engaging in business together. So formation is free, but also can happen accidentally, which can be a problem. And it can result in unlimited liability. Now, when I say unlimited liability, I don't mean half-half. I mean both are fully liable for everything. So so either can be left holding the entire bag. If you're in a 50-50 partnership, it does not mean you're liable for half of the debt. If that business runs up $1 million debt, that debt collector can go against any of the partners. If there are 50 partners, all of them are joint and severally liable for that entire debt, which means that they have to pay the debt. If someone wants to sue one partner out of 50, that person, if they lose, will have to pay and then have to seek contribution from the others. Each of them is joint and severally liable. The liabilities are not split half. You're not liable for just half. Everyone is liable for the whole thing. That's what unlimited liability means. Do you have a question?
I do. So does that often impact who is permitted to be a partner? Is that a consideration for people? Because if they're insolvent, they don't want to be left holding the bag.
So if you get involved in a partnership with someone who has $0, they are essentially judgment proof. Right? There's nothing to take from. And the other partner, the wealthy partner, that's going to be the litigation target. So absolutely something you would think about. And in addition, that person might be more risk-taking because they have nothing to lose. I mean, if you're in a partnership and you're both fully liable, but one person has $1 million to lose and the other has literally nothing to lose, that person who has nothing to lose might take risks that the person who has $1 million to lose might not. So that's called an agency cost. And so both are agents of the business, both can bind the business. If you have one person who's going to have a much greater risk-seeking type of behavior, you may not want to partner with that person. That may be a bad fit from a relationship perspective. And yes, in terms of who's going to have the crosshairs on their back if the debt collectors come to sue, I mean, we all have that sensibility, right? Litigators follow the money. You're not going to sue someone who's broke. What's the point of that? You might get a judgment. You're never going to get paid. They'll sue the guy with $1 million. So a general partnership has a lot of risk to it. So, in addition, if you don't form a partnership agreement, which costs some legal dollars to put together, there's going to be a lot of questions about how that business is managed. So it is easy but it's rarely the right choice because of that liability. So it's one that we can usually dispense with pretty quickly in any type of business that could incur liability. If they're coming to your office and they're asking you for legal advice, do you think they want to walk away with a situation where they could lose their home, their money, their bank account, their savings? They're looking for protection. And so a general partnership is rarely going to be the right choice, but still it's something to discuss. We're going to step through the choices. It's one of those easy ones we can usually knock out for any business that might incur liability. In the case of My Green Home, let's apply that here. They're installing solar panels on people's roofs. Can anyone see a situation where that could cause liability? Yeah, what if a worker falls off the roof? It's a $5 million lawsuit. 33-year-old guy with 2 kids falls off a roof. You know the jury's in Pennsylvania. What's the wrongful death going to be on that one? Do you want to pay $5 million? Probably not. Probably not. In addition, if you're going to be buying solar panels and warehousing them, you're going to have a lot of inventory. And so you're going to owe debts to those suppliers because you've got a lot of inventory that you have to pay for in advance, maybe pay on credit. You'd be personally liable for that if you don't sell those solar panels. And see how the weather holds up, but that's an issue. If you're in the business of installing solar panels, you may also damage someone's roof, cause property damage in the process. We have some older homes in this area. My home was built in 1924. I'm not sure it could handle the weight of a solar panel on the roof. Do you want that liability? Solar panel comes crashing through a roof, kills my dog. That's a lawsuit, right? Personally liable, unlimited liability, right? So a lot of risks going on here. But it's important, and I'm trying to reiterate that it's important to address those risks and not just ignore them, not just skip the entity choice. It is one of our choices. It does form by default, but I want you to address why it's usually not a good fit. This is one of the easier ones to deal with, but I do want you to talk about that as you step through the choices. You can usually dispense with it pretty quickly. It's rarely the right choice. How about a limited partnership? What is a limited partnership? How is it different than a general partnership? Yeah, Danielle.
You have one general partner that manages how to allocate the investments, and you have other limited partners that are passive and don't control the company.
Great. And why would a person be passive? Why would they choose to be passive?
Because you don't have any exposure to liability.
Right. So limited partners also don't have liability. So this structure is a little bit better for certain types of organizations. The general partner is still going to have unlimited liability, but we can solve that. How do we solve that? We talked about the solution, the common solution last week. You make a corporation the general partner, and then the corporation is liable, and that blocks the liability. But that adds expense. Is it worth the expense? I mean, we've actually seen the development of limited liability companies to address exactly that situation, so you don't need that additional blocking entity, that liability blocking entity. But this type of form is very popular for a very particular type of business. What type of business usually prefers the LP form, almost for historic reasons? Investment funds do. Investment funds, and being an LP is almost a sign of being an investment fund. I mean, for one thing, investment funds have a lot of money. And so the cost of having a blocking corporation, $200 a year, look, if you've got $500 million under management, $200 a year doesn't matter. Just doesn't matter. I mean, it's basically inconsequential. And if you're able to raise money even 1/50th easier, if you have it even slightly less legal, I mean, you can sneeze those legal fees if you're building an LLC, right? So for a complicated LLC with a big management structure, and everyone has to read an 80-page operating agreement, LPs are more generally understood. It's sort of the standard form for an investment firm or an investment vehicle in a firm, really. It's really even a fund. I wouldn't even call it the firm. The firm might have a partnership structure or an LLC structure, but the actual investments themselves are usually done through funds, and those funds are LPs. So when I see a limited partnership, I think investment fund, and I think you should go in that direction too. Its advantage is historical. People are used to them. You can use an LLC to do the same thing, but LLCs don't have the same connotation, and I guess the other reason, which is a little bit less marketing and maybe a little more sensible, is that people who are investing in funds, they're used to being limited partners. They've been limited partners before. They know what a limited partner agreement should look like. They know what to look for. They're aware of the rules and the law. So, you're going to try to make it easy for your investors. You make it easy for your investors by being ordinary, by being vanilla, by not being too complicated. So if you could do that through an LP, that might be a good reason to spend $200 a year on a corporation. But usually, and it's worth talking about. I mean, if you see a relationship of a real operating business, okay, it's worth talking about the LP structure because, let's say Anita is just money, but there is an issue with being an LP. What is an LP allowed to do under Pennsylvania law? Basically nothing, right? They have to be passive. And so if Anita wants any involvement in the business whatsoever, an LP structure is not going to work for her. If she does want to be totally passive and she wants to feel like an investor and be an investor in essentially a fund, this is a colorable choice, and we can set up a blocking corporation to prevent liability for Brandon. We certainly don't want, and Brandon doesn't have a lot of money, but he might someday. I mean, let's say this business works out. Brandon will become wealthy. So it's not that he's going to be hopefully broke forever. He's broke now. He just graduated CMU. He's got student debt, but he's trying the startup, hoping to make something of himself. He's not going to be broke forever, and so we want to make sure he's protected in the long run. So if we're going to set up a GP structure, we want to think about liability for the GP. We want to think about a blocker corp. And again, we ask, is it worth the cost? Why? Why are we doing it this way? Well, if there's historic reasons, simplicity reasons for attracting multiple outside investors, sure. Otherwise, less likely. All right, the corporation. Corporation suitable for specific purposes. What are the features of a corporation that make it different from these other forms? Centralized management. Unlike a partnership structure where you have to have either a totally passive member and a centralized management of GPs, you have sort of professional, and you won't necessarily, but you can have professional management. You can hire people who manage the company, and there's a separation of management and ownership. And so that can be very helpful for certain types of companies where you want to bring in an outside manager. I have a twist on the hypothetical later where we have Anita and Brandon who both want to be investors. They want someone else to run the company. That looks more like a corporation, especially if they may want to get rid of their investment because corporations have transferable interests. It's fairly easy to sell your shares. So if these are short-time players, if Anita wants to get in, has the opportunity to get out, if Brandon wants to be able to maintain the company even if Anita wants her money out, if he wants the capital to be tied up until the company decides to let her go, the corporation is a great choice. And the only reason not to choose it at this point is for tax reasons, because corporations have a feature that we'll discuss called double taxation. But if we can get into the S corporation checkbox, we can avoid that corporate taxation. We're going to talk about S corporations a little later in the lecture today as we talk about tax implications. So in a corporation, the shareholders simply provide capital, although they do have more control than an LP. Why? What can shareholders do that an LP cannot?
Vote.
They can vote. They can vote for the directors, and so they can exert pressure on the directors. And so if Anita has all the shares, she has all the power, and she might appoint someone to be a director, but she can then remove that director much more easily than an LP could remove a GP. So an LP, remember, especially in Pennsylvania, has no power whatsoever, is entirely passive. A shareholder in a closed corporation is going to have some more power than that and some additional transferability of their interests. It's a little bit more of a fungible commodity, a share in a corporation. That clear separation of ownership and control may or may not be desirable. We have to play that tape forward a little bit to see where we get to. The other thing is that it's a very clear structure about authority. So as was mentioned, a corporation has centralized management. What does that mean? It means the board of directors has to get together as a whole and vote on major things. It's very clear who acts for the corporation, and it's very straightforward. If you have a partnership with a number of partners and they all run around with authority to bind the company, a partnership can end up being involved in deals that maybe a majority of the partners wouldn't want. It has much more decentralized management. Here we have a clear structure. On the other hand, right, Anita is not going to have much authority. Voting for the directors once a year, if that, it's not a lot of power, not a lot of authority. She is owed some duties, but as we will see next semester, it's hard for her to sue about that. So again, a corporation is going to be a useful entity in a number of areas, especially when you want to have centralized management, when you want the separation of ownership and control. But you don't want to give up complete authority. You don't want to be, run roughshod over. And there's going to be, it also has the advantage of perpetual existence. So, The corporation will keep that capital for an indefinite period of time, so it's a long haul kind of business. It's also a good form to attract outside investors because people are used to buying shares in a corporation. And you know what you're getting. If the corporation has 1,000 shares and you have 100 of them, you own 10%. So it's pretty clear what you own. In a partnership, you have to negotiate everything separately. But shares are shares are shares. 10 out of 100 is 10%, and that's your rights for voting, that's your rights for distributions, that's your rights for dividends. So corporations are really straightforward, and that has an advantage in many, many cases, and so it's a form that we're going to learn a lot about in this class, and it is the form that large Fortune 500 companies have adopted. I actually read a statistic today which was astounding. Apple is the wealthiest corporation in America right now, and I was shocked at this. They receive 16% of all the revenue of all the businesses in America. It's an unbelievable concentration of wealth. The top 3 corporations in America, the top 5 corporations in America, which at least when I read this report, Apple, Alphabet, which was Google, Microsoft, Cisco, and I'm blanking on the last one.
So that, I don't know the last one. I was just asking, you said 16% of all the revenue.
Of all the revenues that all the businesses generate in America. Apple posted $229 billion in revenue, and the statistic that I read said that American businesses generated $1.4 trillion in revenue in 2017, which shows that Apple had a 16% share of all the revenues generated. I think that statistic might have been their worldwide revenues, and this, so it was hard to get the numbers to. It was an unbelievable, vast percentage of American revenue going to a very, very small number of corporations.
That's what I wanted to clarify. I was like, that's a lot.
The top 1% of corporations hold 50% of the cash that all corporations hold. So if you think that the whole 1% thing is a big deal in personal wealth, it's even more magnified in corporate wealth. Question?
So that's consumer revenue, not like business revenue?
I think it was both. Yeah. It was hard to get the statistics. The statistics came from the Census Bureau. They did a 2015 census, and the Small Business Association. And I'm kind of spitballing just to kind of make the point. I mean, don't cite me on this one, but Google it, and the numbers that I saw showed $1.4 trillion in total U.S. receipts, revenues for businesses registered in the United States, and $229 billion for Apple. So, in any event, the cash position alone is astounding. I mean, when you add up the 5 largest corporations, they have 1/3 of all the cash that all corporations hold, all the liquid cash. It's an unbelievable concentration of wealth. It's been very effective at concentrating wealth. It's not appropriate for all situations, though, especially in small businesses. It does have that double taxation. And the double taxation, at some point, you won't be able to get around it. You can't zero out all your income. You can't form an S corporation in a lot of contexts. And, it doesn't have certain flexibilities to it. So, that separation of ownership and control, that may not be what the founders desire. Which is why the limited liability company often comes up. And in addition to the corporation very frequently being a valid choice, at least an S corporation, the LLC has many, many features that make it always something to talk about. You should always consider the LLC because it has such flexibility. It can be many different things. It can function like an investment fund, or you have a manager managing it, and members who are passive. They could be fully passive, like an LP is required to be fully passive, or the operating agreement could give them some additional control rights. And you can set up the distributions however you want. You don't have to have the distributions tied to the contributions. In a corporation, your share is based on how many shares you bought. Your percentage is based on how many shares you paid for. And that says how much you're going to earn. It's very straightforward, but you may not want it that way. It may be that a person who works gets a share, even though they contributed no money or small amount of money. You may want a 50-50 share. I brought the rake and you brought the lawnmower, right? Very different values of our capital contributions, but maybe we have an agreement to split the profits 50-50. An LLC can achieve that. We can really set up the plumbing, we can pull all these levers, and we can write a fairly complex operating agreement to get things tuned in just the way we want. But don't go running to the LLC every time, because that flexibility comes at a cost. I mean, we're going to spend next week and the week following going over the documentation to build a corporation. You're going to leave this course with the capacity to form a corporation. You are not going to leave this course And in fact, even if I taught an entire course on it, it would be hard for you to leave with the capacity to build an LLC. You'd have to understand ramifications of tax law, about partnership law, and various other things which are quite complex. So an operating agreement for an LLC, at least with multiple members, could be 60, 70, 80 pages, and it's hard to understand. There's a bunch of different tax ramifications. You have this flow-through status. You have issues of what's called phantom tax. If the business earns money and doesn't distribute it, the partners may owe that tax even though they didn't receive the cash. The cash may be stuck in the business for one reason or another, and then the members of that company, the tax flows through to them, so they owe the tax, but they don't have any cash to pay it. And so that phantom tax is going to be an issue, and you have to work around all of these things. So, like I said, it's not a course on LLCs, and I spend a full week on it in venture capital law to understand the LLC operation. It's really a week and a half to introduce it, and that really only scratches the surface. They're really complex. So the flexibility, you only really want to use them when the flexibility is important. There is the advantage, however, that you can have flow-through taxes, meaning no corporate taxation, even if you don't meet the standards for an S corporation. So we're going to get to this in a minute, but in order for it to be an S corporation, all the shareholders have to be U.S. taxpayers. Not true of an LLC. So anytime you have a foreign investor, you want to really strongly consider the LLC if you're looking for flow-through benefits. Because if you can't make the S corporation status and you're concerned about the taxation, then the LLC might pay off. This is a high revenue business. If there's going to be a lot of money flowing through this business, you don't want to be paying double taxation on all that money. And if you can't make the S corporation election because you don't meet the standards, and we'll go over, there are 5 standards that have to be met for an S corporation. If you can't meet those standards, an LLC is an excellent choice because you will be able to enjoy perpetual flow-through tax treatment, if that's what the founders want, as well as whatever structure you need at a higher startup cost. The other problem with an LLC is because of the complexity, because of the flexibility, each one is a little bit different, and so investors are more wary to invest in them because they don't know what they're getting without taking a very careful look. And so you come to someone and you want $10,000 and it would cost $10,000 of legal fees for them to review the agreement. They're probably just going to say no. Whereas a corporation, again, it's much more clear what they're investing in, and people make small investments into corporations all the time, in part because they know what they're going to get for that share. It's much more straightforward. So the flexibility can be very helpful, and it can be very helpful especially when you're not able to get flow-through status with an S corporation because you blow the S election. Then it might really pay off. But before you charge your clients 5 times what it would normally cost to make a company, make a corporation, and before you get involved in something complex that you may not have the capacity to do without reaching out to tax counsel and learning about partnership law, and you might want to think twice about that. The other aspect, which is an issue, it comes up less here, but something to think about, is that we're going to learn about veil piercing, which is the doctrine that says that we're not going to honor limited liability. So shareholders generally have limited liability, but we will spend 2 weeks on a doctrine that explains when a debtor or a tort, the tort fees is the one who commits the tort. Is there a word for the person whose tort was committed against? The tort feased? The plaintiff. No, I mean the plaintiff here. The tortfeasor would be the tortfeasor is the defendant. The plaintiff in a tort case, I'm going to call the tortfeased. So, you got a tortfeased, and they're going to come after the shareholders, and they're going to have some ability to get to the shareholders in certain cases in closely held businesses. We understand that law pretty well. I will teach it to you. I will give you what I call a piercing scorecard, a set of factors. I will rank those factors. I will make it very, very clear when piercing is likely in a corporation. I cannot give you such a scorecard for LLCs. The law is not that well developed. And so there is just more risk. There's just more risk. They've only been around since 1992. We adopted a newer version of the statute, 2001 or 2007. So, this is there aren't that many of them. There aren't that many lawsuits. Every state has a different law. I just can't tell you when they're going to pierce. And that's a risk. And so you would at least need to inform your clients that down the road, now this is less relevant, as we'll see. Piercing doesn't happen in larger companies where there's multiple shareholders. It has to do with the concept of the company being the alter ego and sort of the instrumentality of the shareholder or the owner or the member. So if you have 2 people, that's a real risk. If you have 10 people, it's not really a risk. But piercing drops precipitously. Most piercing happens if you have 1 person. And speaking of 1 person, a single member LLC is easy. A single member LLC is very easy to set up. You only need, it's basically a 1-page document, because you're not dealing with you're not dealing with all these levers. There's only 1 holder, so he gets all the profits, she gets all the profits. Right? Oh, and by the way, just as an aside, you can elect to have the LLC taxed like a corporation too. I mean, truly flexible. And under Pennsylvania law, the LLC can convert from a manager-managed to a member-managed and back again without any additional filings. Huge amounts of flexibility. The question is the flexibility worth the cost? Is the flexibility worth the liability risk? And so, you want to put on your lawyer hat and balance those things out. Finally, I want to mention a sole proprietorship. A sole proprietorship is just when a single person goes into business and does not do any work to protect themselves. A single proprietor can hire an employee and pay them a salary. A single proprietor can take out a loan and owe a debt. And in both cases, that single proprietor maintains complete and exclusive control. Now, it's free and it's easy, and they can walk out of your office and do it tomorrow. Of course, the risk is the unlimited liability, but for companies that can't afford your bills, and for the person's only responsible for their own actions, except to the extent that they have an employee, and then there may be the doctrine of respondeat superior. It's an agency principle. Let the superior answer. So sole proprietorships are worth considering if it's really just 1 person running a business. I mean, people do that, but you have to inform the client that they're fully liable for any torts or debts of that business, fully personally liable. There's no insulation for that person. So it's something to mention, but just like the general partnership, it is usually not going to be your best choice for any company that could incur liabilities. I mean, if it's a kid doing a lawn care business, in the summertime, maybe that's fine, I mean, because liability is pretty limited for something like that. It's not 0. You can still run over someone's hose or, maybe injure someone, it's possible. But, you weigh the costs and benefits. Or does that kid want to spend $10,000 over the course of 5 years on various filing fees and startup costs to make a couple bucks? And so, if that's the kind of client that comes in your door, I think the answer there is maybe you go ahead and you take that risk. But the problem though, it's worse in a partnership where then you have the risk of someone else's actions. You can control your own actions to a certain extent, but if you have a partner that's running roughshod and so a general partnership is even riskier than a sole proprietorship for that reason. Do you have a question?
Aside from the liability aspect of it, being a sole proprietor, would you agree that it's harder to, it's more challenging to get funding or?
Well, there is no concept of funding. There is no concept of funding. The only way a sole proprietor gets funding is with a bank loan.
Right.
You can't sell a share in that business. There is no concept of share. There is only 1 owner.
Okay, I guess I was just asking. My mother started her own business actually about 10 years ago, and her biggest hurdle, once the business was open, everything was great. The biggest hurdle for her was going to banks trying to get money, because a lot of them looked at her as, you're just one individual who has experience in this one area, why would I give you money versus, the way I looked at it was, well, you're not a collective group trying to go in there buying into this idea. You have to sell it more than you would if you were in a large organization.
Well, unfortunately for your mother, women are disadvantaged in the lending market. I mean, women are denied, women who have equal capacity, and if you regress out all of the other details, age, education, experience, women still get loans half as likely as men do from banks, especially larger banks. It's one reason community banks are helpful for women and minorities to a certain extent. Certain laws have made those banks go away, which is an issue. So part of it is that she's out there as a woman and she's disadvantaged just by basis of bias. And if she were a corporation, even a female-led corporation, that would increase her chances just because she's not going to be castigated in the same kind of way. So that was a particular aspect that affects, only about 50% of the population. But there is something to a sole proprietorship seeming more risky because that individual, the whole company lives and dies literally with that individual, and so it cannot operate as a going concern without that individual. Even if it's a corporation that's only owned by one person, if that person passes away, people can inherit the shares and continue operating the corporation, and so it has more as a going concern. Now, that said, banks probably won't lend to a brand new corporation either, because they won't be able to collect for it. So in that case, though, the sole CEO, the sole investor, the sole owner could give a personal guarantee. And so you'll often find that banks will demand that personal guarantee for young companies. Like I mentioned, I have this little consulting business, and I went out to get a car, and I had to sign both as president and personally, fully on the hook for the car payments, because the business had only been operating for a year and didn't have a lot of assets, and so they knew that if they had to collect, that would be hard, easier to collect from a person. They were willing to sell the car to me. They're equally willing to have. You get two bites of the apple then, right? You have two people on the hook for the liability, and so that also helps. You can go after the business, which has its assets, or go after your mom and her assets. That's better than just being able to go after your mom. But it does speak to a broader societal issue that there are these, but there are ways around that. There are ways that you can, it costs money, but then if you form a corporation, there are some benefits to that. Yeah.
There's benefits to each. I just remember when it was like an undergrad. She was asking me, oh,
Yeah.
gosh.
Well, you were a business undergrad, yeah. So.
Corporation. I was like 18. I'm like, I don't know.
Yeah.
So.
The answer is probably yes, even just to avoid some of the liabilities. If not, if I'm driving the company car on company business, even if I'm liable for the payments on that car, if I get an accident in that car, at least I'm not then personally liable for that, right? So that liability shield can be helpful. Even if you get involved in some liability by essentially co-signing for certain debts, at least you've pushed off liability for certain torts and maybe other debts.
So would your business, like your small consulting business, eventually receive a credit rating, or is that
Yes.
something you-
Yes, it has an EIN number like my social security number, and with enough history, it does develop its own credit. Apple, no one needs to co-sign for Apple, right? And so obviously there's a huge difference, but everyone starts somewhere. Not that I will ever get there. That's simply not going to happen, but at least you can understand the continuum. And no one is co-signing for Apple because they have in fact, public companies get a credit rating from agencies that specialize in that. But from what I understand, any entity with an EIN, an employer identification number, has a credit history, and the credit bureaus track that and provide like a FICO score for it.
So it would be like movies or whatever.
It wouldn't be, I don't think so. It's not I don't know for sure. My understanding is that an EIN is the same number of digits as a social, and often you plug it in place of that. And I think that Fair Isaac and the Experian, TransUnion, and Equifax, they track the credit history of that EIN, and that EIN, that entity that's registered with the IRS in that fashion, develops its own credit score, automated credit score. But no, I'm not going to get rated by Moody's anytime soon. Yeah, in fact, most private companies don't. But private companies do borrow. Uber has entered into deals. Lending Club did this right before they went public, so if anyone really is interested, that document's actually available, because Lending Club, as a private company, took on a $100 million debt, used that to buy a couple startups on a private deal, so a leverage acquisition, and then went public and disclosed the loan agreement. So if you're interested in seeing what a private company loan agreement and how, and so instead of ratings, it's often like a lot of mechanisms like escrow agreements and various contractual provisions that effectively give the debt holder some control over the business and a lot of ways to call a default and pressure them, because they don't have that credit information as much as a public company would. So a sole proprietorship is an option, but often not going to be the best one. So those are going to be your main choices, and I'd like you to look at all of them. Obviously, there's reasons not to select one, and then you can dispense with some of them quickly. But especially on like kind of the first set as you go through the hypothetical, go ahead and talk about all those choices, even the ones that you're going to rule out. Just rule them out quickly.